All right, y'all, from there we are going to head on over to the Texas House, where that Committee on Criminal Jurisprudence is now underway, where we are expected to hear from Robert Roberson himself. Let's take you there.
I'm very disappointed to say I don't believe that will happen today, and I'd like to go over why that is. As many are well aware, there's been a flurry of litigation in the Texas Supreme Court over the weekend. The upshot of that is that a valid legal subpoena for Robert remains in effect. That we could enforce that subpoena. But we didn't issue the subpoena to create a constitutional crisis, and we aren't interested in escalating a division between branches of government. To come together in our purpose here, which is other facet of our government, and we want to making sure that Robert is heard. There's been a lot of discussion about video conferencing Robert in today. I believe that that'd be perfectly reasonable for most inmate witnesses. But Robert is a person with autism who has significant communication challenges, which was a core issue that impacted him at every stage of our justice system. He's also spent most of the last 2 decades alone, locked away from the modern technology we now take for granted. Video conference is poorly suited for Robert specifically to provide his testimony and would only further the harm he's already suffered. When I thought about the accommodations to be made, I considered his needs as a person with a disability above all other. To video conference. That doesn't mean Robert won't testify. In the spirit of cooperation, we are in talks with the Attorney General's office right now about ways their position can be addressed while allowing our committee to hear Robert in person. I expect a quick resolution to these discussions, which are ongoing even at this moment, and I will update everyone as soon as those plans are finalized. At this time, I'd like to invite any member of the committee to make any opening remarks. Mr. Vice Chair? No. Chairman Leach.
Thank you, Chairman Moody, and thanks to those of you who are joining us here at the Capitol today, and to my fellow committee members, fellow legislators here in the room, to Texans who are watching on television, and welcome to all of the non-Texans who are tuned in across this country and really all over the world. We are honored to sit in front of you today, and unlike Washington, to show you that government can work, and that Republicans and Democrats can work together, that death penalty supporters and death penalty opponents can work together, that the branches of government, the legislative, the executive, and the judicial branches can work together. When it comes to our fundamental duties as legislators, it's very simple: to protect at all costs the fundamental rights and liberties of the people, most importantly of which is the right to life. And when it comes to the life of a potentially innocent Texan, someone who I have, over the past several weeks, grown from having questions and concerns about to believing he is fully innocent, and was within 20 minutes and 20 steps of being executed by the state of Texas just days ago. If we can't speak up and step up and work together to fix a system that is not broken in and of itself, but that needs fix, that has failed Robert and failed Nikki, then what are we even doing? Today, this hearing, the purpose of this hearing, our purpose for coming together and issuing a subpoena to Mr. Roberson and to convening last week and today and in what is likely a subsequent hearing, is to ask questions and to find the truth, to figure out where the system went wrong, where it failed Nikki, where it failed Mr. Roberson, and to try to fix it. not only in his case, but to make sure that it never happens again. In closing, I'd like to make very clear, members and Mr. Chairman, remind ourselves that when we take our oath of office, we solemnly swear that we will faithfully execute the duties of our office of state representative of our state, the state of Texas, and will, to the best of our ability, preserve, protect, and defend the Constitution and laws of the United States and of the state of Texas. That oath of office I take seriously. I know each of you take seriously. And importantly, that oath of office is the same oath that judicial officers and executive officers take. And the legislative branch today is taking our oath seriously. And I'm honored to be here with our fellow members, and I welcome all the people tuned in to the Texas House of Representatives. Thanks for joining us today.
Chairman Darby.
Thank you, Mr. Chairman. First of all, thanks to the members of the committee for being here today, and thanks to the members of the public and other fellow members of the legislature that are sitting in the third row. I want to build on Vice Chair Leach's comments about our role here today. I'm probably the senior member on the dais this morning. I've been here for a few sessions, and I want to focus the committee and the Texas House on our role and responsibility under our Constitution. Our job is to pass laws, and we do so because we listen to the folks who elected us to come down here and make those decisions, to do the hard work, to focus on an issue, come up with the right policy, and then hopefully we'll pass that policy and it'll make a difference in people's lives. Over the years, certainly during my time here in the legislature, there was a flaw in the system. There was a flaw in the habeas corpus process. There was not a mechanism by which people could appeal to the court to grant relief in a situation where science has changed. Now, they refer to it as junk science, but I would say it's just science has changed. The knowledge has changed. And so we saw a problem. So in 2013, and I think Chair Moody and Chair Leach were members of this committee at the time under Senate Bill 344, this legislature took up this issue. We said, let's create some basis of understanding that would allow relief for people who've been charged and are serving time to address the concern about changing knowledge of science. We did that. We set up steps that the Court of Criminal Appeals could look at. Well, we didn't go far enough. And 2 years later, in 2015, we revisited the issue and we changed it again. We changed the steps. And so what I would like this committee to focus in on, I'm not here to determine guilt or innocence. That's not my job. What I am here to do is, has the legislature failed in properly addressing the tenets by which the Court of Appeals can review these cases? Since the implementation of this law in 2013, there have been 74 applications for writ of habeas corpus based upon junk science. Roughly 25 of those cases were people on death row. None of those cases have been affirmatively reviewed and remanded. None of them. The other approximately 50, 2/3 of those, about half of those have been sustained. That science has indeed changed, and so we're going to we'll allow new evidence to support a rehearing or a retrial on that case. All of those cases pertain primarily to DNA analysis. We all have gotten caught up with DNA, and we understand that science, and so we recognize that has the ability to determine that the accused didn't do it, but somebody else did. But there's no cases that have been successfully appealed that take a look at the tenets for the shaken baby syndrome that we're dealing with today. Clearly, that body of evidence has changed. And so it's up to this legislative committee to look at the tenets of what's going on here. Has the Court of Appeals taken a position that is inconsistent with the statutory language that we have set out for them to follow? Are they ignoring that and saying, well, yes, it's changed, but it does not determine who the guilt or innocence? That's a level beyond which I originally envisioned in 2013 and 2015. That's a higher level. Is that a level this committee and the legislature wants the Court of Appeals to review these cases? That you actually have to have the scientific facts determine the innocence of the accused? I think not. And in this case, I think so we need to be looking, what I'm looking for with the witnesses is how are we as policymakers to look at the statute that says this is the criteria by which and the lens by which we will review the facts of this case and determine whether or not a new trial should be justified. That's what our business is. That's what our business is, not to determine guilt or innocence. It's not to argue about the death penalty. It's to determine that we as legislators have created hurdles in statute, and is the Court of Appeals following those hurdles in the spirit by which we were intending them to follow? That's what this committee is about. It's not about guilt or innocence. Guilt or innocence will be a byproduct of our hard work. Thank you, Mr. Chairman.
Chairman Darby, thank you very much. Ms. Representative Harrison.
Thank you, Chair. I want to start off by thanking everybody who's taking the time to tune in or come to this incredibly important hearing today. And I also want to start off by thanking every member of the Criminal Jurisprudence Committee for voting on a bipartisan, unanimous basis for the issuance of what was admittedly a historic and wholly unprecedented subpoena. I'm grateful for each one of you for taking such a bold action that, even though it was historic and without precedent, I firmly believe it was absolutely necessary given the extenuating circumstances in this case. And without wanting to get too philosophical, I do want to remind everybody that in our country and in our state, in the great state of Texas, it is the people who write the laws that govern them. And they do that via their elected representatives in the legislature. So it is incumbent upon us to make sure that the laws that are duly enacted by the legislature are being faithfully adhered to by those who are subject to them. And so for people out there who have concerns, who have raised questions about separation of powers, I want to be unequivocally clear. If you care about the maintenance of the proper functioning of our constitutional system of separation of powers, you should be the loudest supporters and the biggest proponents of what this committee is doing here today. If the House of Representatives cannot exercise legislative oversight to make sure that our laws are not just being faithfully adhered to, but that they are not potentially being so egregiously violated that it may result in the life of a potentially innocent person being taken by the government, then I would posit there may be no matter that could be subject to legitimate legislative oversight. The role of government, ladies and gentlemen, is the protection of life and the protection of our liberties and our freedoms, which do not come from the government, but that are endowed, as our founders knew and codified in our founding documents, in an inalienable fashion, endowed to us by our Creator, and it's the central role of government to protect them. So especially when we are weighing something before us as constitutional officers of the state of Texas, where a man's life literally hangs in the balance, and we are contemplating the government exercising the ultimate and most awesome power that we give a government, and that is to take a life, we cannot get this wrong. And I say that as somebody, ladies and gentlemen, I want the state of Texas to lead the nation in just about everything. But executing potentially innocent people is not one of them. I do not want my children, and I think I can confidently say this for my colleagues on the dais here, I do not want my children to inherit a state where potentially innocent people may have their lives deprived from them by the government. So in closing, I want to just thank not just my colleagues on this committee, but every single member of the Texas House of Representatives who has spoken up and has unified and is making the conscious decision to put aside partisanship and put aside the issues that usually divide us so that we can come together in the pursuit of justice. Thank you, Chair.
Thank you, Representative. Any other members have opening remarks? Yes, Representative Bowers.
Thank you, Mr. Chairman, and I don't have much to say, but I just would like to say thank you to all the members of this committee for every bold and courageous move that was made by those here on the dais as well as those that are out in the audience. There's a higher being that knew that each of us in this room would be here today at this moment and for this time. And so I just want to say thank you all for being here. And it is historic that we are all sitting here and we are going to make some decisions that hopefully will bring positive change to this state. Thank you.
Thank you. Any other members with opening comments? Nope. Okay. Before I begin, I'm going to just let you know who the witnesses are that we'll be hearing from today. I'm going to list them in an order that I intend to call them. I want to be very clear that those things can change with schedules and logistics, but I'll go through that list now. Dr. Philip McGraw, John Grisham, the Honorable Elsa Alcala, Terry Compton, Kate Judson, Don Salzman, Dr. Natalie Montfort, and Gretchen Swine. At this time, the chair calls Dr. Philip McGraw.